Yeah, sorry about that.
It's all good.
No problem.
I really don't know what happened.
I was telling Brad, I'm sure you've all got our webinar stories of where something like this has happened.
Oh,
So we've been doing this 2017, 2016, something like that. This is the first. I don't
well,
know.
it's gonna be a record breaker then.
Yes. All right. Maybe somebody was going to say something FTC didn't want to hear.
I hear you.
They were preempting. Anyway, sorry about the snafu. I hope that the people who were on find us again. So it's coming through on a separate broadcast this time, but it'll be up on the Dealer Refresh channels. So anyway, we'll have the recording and everything that'll be there forever. So anyone who misses anything, they'll have it. Well, thanks for your patience, and sorry we lost 10 minutes there. But
No worries.
well, anyway, I appreciate you two joining us today. We've had compliance, regulatory items, things of that nature have unfortunately been thrown in our face quite a bit, especially lately. And now it's hitting all parts of the dealership, isn't it? Like we all have to be thinking about it on a daily basis almost.
Well, certainly from our point of view, we do, and thanks, Alex and Jeff, for having us on. Chris, I'll let you jump in, but from my perspective, I have a little different perspective. I'm recently with joining ComplyAuto from the NADA, where I had a little bit of a different insight from Washington D.C. At least on the federal level, the answer is absolutely. And I think what a lot of folks in the dealer community may not fully appreciate is that unfortunately dealers have a target on their back for a variety of reasons. They just do. The Federal Trade Commission, which is the primary regulator of dealers in Washington D.C., at least on the consumer side, they make a point out of the fact that they generally don't regulate housing. So the purchase of a vehicle is the second largest generally financed transaction or transaction that most people have in their lives, and so it has a particular focus just by its nature. And sort of ideologically, the folks at the FTC now are un- are very activist, very ideological in terms of their views of what it means to protect consumers, and it's very paternalistic, which means rules, which means restrictions on dealers. And so, at the end of the day, the sort of the 50,000 foot message for dealers is, look, if you're hearing about these things, it's not by accident, right? It's not happenstance that they're trying to make things that you do more difficult. They want to make it more difficult to market, to communicate with your customers, to have negotiated transactions. They don't like the concept of negotiated transactions. So many of the things we do inherently just raise the temperature, but certainly at the federal level, but at the state level as well. And so the answer is yes. Certainly, from a privacy data security perspective, you have the additional sort of influence of an explosion in risk and an explosion in the use of these kinds of tools. And anytime the market gets ahead of the controls, you're going to have gaps. And so you really have to think about the way that you adopt these things. Everyone's in a rush to do the right thing by the consumer. You sometimes have to take a step back and say, okay, let's make sure we're doing it in the right way so that we don't put our consumers at risk. So there's a lot of things at play, both from a regulatory perspective, from a regulator perspective, and from a practical perspective that are really driving this. And I don't think it's going to stop anytime soon. So great. And we could expand on that. There's unfortunately a lot more to do. It's not all bad news either, because certainly in my view, because there are benefits. There can be even business benefits to doing the right thing in many of these cases. And so we try to make sure the dealers are aware of what they need to do and really are thoughtful about the way they do it. Because if you it's just like anything else. If you think of this as an afterthought, you're not going to do it right. It's just going to create more problems than you solve. So there's a lot going on for sure.
Well,
Do you think a
that's a
lot of these
strong opening.
rules or this whole cars did this come out of necessity, were consumers asking for this? Were there enough complaints across, uh, you know, the purchase of a vehicle where, there are so many issues and such? Was the public speaking up and complaining about this, or was this just something sort of slapped on us?
Well, the cars rule. So the cars rule is a big topic. Now, there's a tremendous history there. I can tell you that this goes all the way back to, I was at NADA for 16 years. I was there sort of right after the financial crisis when a federal statute called Dodd-Frank was passed. And what tends to happen with the U.S. regulatory regime is that when there's a financial crisis, they respond by ramping up the regulations, right? So Sarbanes-Oxley happened sort of in the 2001 time. In 2008, it was Dodd-Frank, and they regulated a whole bunch of things, right? Because hey, something went wrong, so let's use our 2020 hindsight to try to pretend like we're going to fix it, and they slapped a lot of regulations on. At that time, there was as you may remember, that's when they established the CFPB. And there was a big fight, and at least franchise dealers are generally not subject to this jurisdiction of the CFPB. And that created, people in DC have long memories, right? They don't take that kind of, to them it was a loss, right? They wanted to regulate dealers, they weren't able to. And so they don't ever forget these things, right? And so what happened was they started out, first of all, there was literally a provision put in at 2 a.m. in Dodd-Frank that arguably gave the FTC some expanded rulemaking authority over automobile dealers specifically. So that's part of what the litigation's about right now. But long story short is they used that authority. They held a series of roundtables 10, 12 years ago. They went around the country asking people for what are the problems with dealers we need to fix. And they frankly didn't find much, right? And it went 10 years without anything happening. And then, elections have consequences. For those who don't know, the Federal Trade Commission is a quote unquote independent commission. So there are 5 members, 5 commissioners, 3 from the party, the president's party, 3 from the off party. So right now there are 3 Democrats and 2 Republicans. And ideology and politics make a difference. The folks Lena Khan has made a name for herself as the chairwoman of the FTC, and for most of the last few years, there's really only been 3 Democratic commissioners and no Republicans. So my point is, they have come in and really taken the reins of a rulemaking, and they want to do a rulemaking for the specific purpose of enabling them to find dealers. There's no doubt they've said so. So it's a great question. When I was at NADA, there certainly were a lot of arguments that they did not prove there was a real problem, and in fact, they cited all these complaints. But of course, as we pointed out, you could cite 10,000 complaints, but out of 40 million vehicle transactions, that's a pretty small number, right? So from our perspective, the answer is no. Not even close. But that didn't stop them from making the rule, and so it's now out there, unfortunately, and so dealing with it's another question. But the genesis of it really was there were a lot of folks who had long just wanted to increase the regulatory burden and the grip on dealers, and like I said, they really don't understand the business model, and they're probably basing it on 30-year-old stereotypes in many cases, or anecdotes of problems. So, and unfortunately, that's what we're dealing with.
Yeah, and I'll add to that. One kind of related topic that you hear quite commonly, I think, both from marketing companies, even some compliance firms out there, that I think is kind of a misconception, is you hear, oh well, for the dealers that are doing the right thing already and complying with state and federal law, like the cars rule doesn't change anything, and even the FTC has kind of pushed that narrative. You look at some of the FTC's public-facing websites, they make comments like, oh, like for dealers that are already, not shady and kind of, doing right by the customers, like cars rule doesn't change anything. And to me, that is
true.
Yeah, it's a fallacy. It's a fallacy. And there's multiple things that will, even for, I came from a dealership that was extremely compliance conscious. We had an entire compliance department and team of lawyers. And that was my job there, was as compliance director. And, we would have to, we did everything the right way, but by the book, and we're going to have to change a ton of things that we did. For example, one of the most impactful, in my opinion, is the offering price requirement that I'm sure we've all heard about, that requires you to list the offering price on any specific vehicle or individual vehicle being offered for sale, as well as any groups of vehicles where financing terms are mentioned. And that, dealers are doing things like MSRP only advertising, which is legal in many states today, where under the CARS rule, you won't be able to do MSRP only advertising. You have to have a specific price for each car that includes any mandatory fees, like a document fee, for example. And that alone is something that every dealer is going to have to change. We can get more into this if we like, but another huge one is finance advertising, finance specials. I mean, the CARS rule will basically prohibit dealers from doing what they all do today, which is expressing the monthly payment on a finance advertisement in terms of a formula. For example, $27.78 per month per 1,000 financed, which is very common because we don't know what the payment's going to be. It's going to depend on the customer's down payment. It's going to depend on the type of car. For example, their credit. I mean, today the average dealer is very common, and a lot of the OEMs require it, is finance advertising like 0% on all F-150 Lariats or whatever it is. And under the CARS rule, I don't think you'll be able to do a broad advertisement, because how do you list a monthly payment? Also, the monthly payment requirement says you have to list any down payment that it's based on. I don't know what the down payment's going to be. It depends on the customer, right? And so that's going to have a fundamental kind of impact on how dealers are engaging in finance. So again, the notion that this isn't going to affect dealers at all, that are doing the right thing, is a fallacy, in my opinion.
Doesn't it
this even goes in
one-to-one communication too? So
I was going to say email. Whenever you get a lead from a consumer, you almost have to, I think I was reading, matter of fact, if I'm not mistaken, you guys had a blog post about it. If someone is sending in a request and asking if a car is in stock versus asking if it's an all-wheel drive vehicle, there's certain verbiage in there that you have to be able to recognize and go, okay, I need to send them not MSRP, but this offering price.
Right. Yeah. So the rule is we call it the first communication rule. And the idea is, if the customer asks about a specific vehicle, again, or a group of cars where financing terms are mentioned, so like they ask about a finance special, that your very first communication with that customer, doesn't matter if it's text, doesn't matter if it's email, a phone call, whatever, the rule is that you must, in your first communication, provide the offering price. So well, come into the dealership to discuss, or let's talk about monthly payment or whatever. You got the very first communication, given the offering price. And I'm sure, as we're all kind of realizing, there's a ton of practical implications and concerns for that. And Brad can get probably more into it better than I can, but I mean, think about your chat module on your website. I mean, how do you enforce that? I mean, if it's AI powered, especially, you're going to need to make sure your vendors are implementing rules. You have to train all your salespeople on that. And how do you kind of oversee and monitor that to ensure that the salesperson's very first communication is that offering price? How do you even do that on a finance special, for example?
I'm sorry to jump in, Chris. I'm just one other thing, just fundamentally to point out for the audience, is remember what's happening here. For the most part, at least in the new car franchise world, a lot of the sort of regulatory compliance functions have been funneled through the F&I office, where they're highly trained, they're compensated appropriately, they understand these things. One of the many things this rule does is it expands those obligations out to everybody in the dealership. So anyone in the dealership, someone is a salesperson's at a barbecue on a Friday night, and someone asks them about a car, theoretically their first communication has to include this information, and you have to record it, and you have to make a record of it and keep it for 24 months, right? So how that's going to, it just shows how they don't understand how the world works. Think about salespeople's use of their personal devices, right? This is a almost ubiquitous problem in dealerships. And actually, we can tell you there's probably 5 other compliance risks that raises. But you're really going to have to think as a dealer and as vendors how you're going to control those and funnel them in the sense that you have to have a record of these things. You not only have to do it, but you have to create and maintain a record that you've done it, and then keep it all for 2 years, right? So like I said, it's expanding the people who have to be trained, who have to understand, not just to an F&I manager, but to all your employees and your vendors, right? Because as Chris mentioned, he's alluded to, these obligations apply to any advertisement, and advertisement is very broadly defined. Any website listing, think about social media. So if someone's on YouTube or Facebook doing a video about a car, and they mention a price and the price changes, they've got to figure out a way to take that video down or change. And it's funny because, of course, the FTC says, oh, just go to the settings and delete it. And it's like, well, that's not how the world works, right? So anyway, we could go on and on. But Chris is exactly right. despite, I mean, the reason that the FTC spins this as, hey, honest dealers aren't going to be affected, but it's just those bad guys doing whatever scams that they're doing. They're doing it they're spinning it that way for political reasons because there's pushback and they want it to make it seem like they're just getting the bad guys, right? But that's unfortunately not what they've done as a practical matter.
I'm still trying to. I'm hung up on how do you know it's the first communication, because most people, though, at least in my time, most of the people I was talking to, they were already in the CRM system, or they were using our service drive, or something along those lines. They had done something with us in the past. So,
Sure. Well, it's to be clear under the rules, the first communication about that vehicle, right? Which makes it seem easier, but it's also more difficult because so the person comes in and says, they ask about the red Camry, you got to get first communication has to have offering price. But then if they ask about the black Camry, your first communication about that has to have the offering price. So it's not tied to the person as much as as an inquiry about a specific vehicle or financing term, as Chris mentioned. So in some ways that makes it more difficult, right? Because I mean, in the real world, how many different vehicles do people ask about? How many communications do you have to create? And this is multiplied each time they make you do one of these new disclosures, which are going to have to somehow be, like I said, captured and maintained. So, it's if there's, I don't know, I don't want to say there's good news, but it's not quite as bad as what the proposed rule was. I could give, we could explain how even more insane that was. But the notion, as Chris said, that this is not going to have a pretty profound impact on processes at dealerships. Once it's finalized is I think a misunderstanding. Which, by the way,
I don't see this helping the consumer out at all.
Well, we could pile ironies on ironies here, of course, because one of the justifications by the FTC for this rule was that it was going to save consumers time, right? So, sure how lording on multiple 10, 15 more disclosures in the course of the transaction is going to save them time, but that's their world. But so yeah, let's be frank about the offering price piece. What they want is a price that includes things like doc fees in it. Right, that's what they want, and that is going to be a fundamental change and shift in thinking for many dealers as well, because you're going to have to really think. I mean, I understand how the market's developed. I understand, frankly, I've been around long enough, even at NADA, to remember, a lot of this driven by sort of OEM practices in terms of having doc fees on the back end of the deal because you're getting paid from the manufacturer a certain way. Now they've sort of morphed into a different thing in the advertising world. But the reality is your advertisements, your communications with folks are going to have to include things like doc fees. I mean, that's the fundamental thing that dealers have to understand. And so, it's not, dealers will overcome all these things. Dealers are the most adaptive people and business people there are, but it is going to require you to think a little bit differently, maybe about your pricing strategies and your advertising practices, because that's what they're at. I mean, I don't want to oversimplify it, but that's really what they're after from a consumer perspective, they would say.
Well, and now that we're on the topic of cars, rule, and pricing, I mean, another controversial requirement that I'll bring up is this new requirement the FTC has imposed about you're not allowed to factor or include in the price of a car any rebates that are not available to literally everyone. So all consumers. And I'll tell you again today that is not. I mean, dealers do this all the time. I mean, probably the most classic example that I see across the country is like the $7,500 EV rebate. It's very common on EVs for a dealer to factor that into the price or just show it as a deduction, right? So it's this is here's the original price minus the EV rebate equals this final price. And according to the FTC, that would be misleading and deceptive, and one of the prohibited misrepresentations they've itemized because that rebate is not available to everyone. There's limitations. So if it can't just be, if it's not a completely unlimited, you can't do that. And so that applies also probably to loyalty rebates, right? And things that, again, dealers will commonly do on a lot of these transactions. And now the FTC has kind of changed the standard, even though they've never kind of enforced it that way in the past, and said you can't include a rebate that is, of limited availability in the offering price. And that's another one that's going to be a big game changer because, again, website providers are going to have to change that. A lot of this is kind of programmed into the websites today, and you see that all the time. And according to the FTC, that's just a no-go under the new rules.
So obviously the ironies are thick. And I hope that NADA is and everyone who's fighting it is successful in getting it bent to a place that's much more realistic for all of us. I, with that said, I've heard from a number of people that they're pretty certain that something is going to take place. So
Yeah, I
what's
can try to yeah, I can try to comment on that. And Brad is obviously much more of the procedural, expert on how, these appeals work and all that, as far as, the right to appeal these types of rulemaking decisions in the Court of Appeals that's currently going on with the NADA, the Texas Auto Dealer Association, in the Fifth Circuit. But in my opinion, look, I think it comes down to even best case for dealers that this, let's say the Fifth Circuit agrees that this rule is nonsense and it wasn't the procedural steps the FTC took were defective and strikes the thing down. I mean, from my understanding, the FTC can just go back, kind of correct its mistake, do it the advance notice of rulemaking, and kind of probably get into effect within a year, and kind of proceed as normal. Also, the FTC, remember that the FTC it has a very broad, what we call unfair and deceptive acts and practices authority, UDAP authority under Section 5 of the FTC Act, to enforce a lot of these issues either way. And they've kind of already demonstrated that. I mean, the FTC recently kind of took action against a dealer, Brad, correct me if I'm wrong, I believe it was in Connecticut, for a lot of these like kind of junk fee type issues just recently, even without the CARS rule being into effect, kind of, I think, demonstrating that, even without these specific rules in place, that they'll kind of, exercise their broad UDAP authority to enforce them anyways. And so clearly the FTC has an agenda that it's going to be hard on getting completed regardless of what happens in the Fifth Circuit. Also, I think there's the FTC has a separate junk fee rule in progress right now that dealers are exempt from because of the CARS rule. They cited to the CARS rule for exempting dealers from the general junk fee rule that applies to all businesses like hotels. And I think the idea would be, if the CARS rule got stuck down, they would just lump dealers back into that general junk fee rule. So I think dealers need to be prepared for the FTC targeting them on these issues, irrespective of what happens, and probably need to be realistic about the FTC getting this passed one way or another, unless we see a big political shift, like with a Republican administration. But even then, it will take some time because FTC commissioners have long terms and they can't just be kicked out for political reasons. So.
Yeah, look, Chris is right. I got to be, I was NADA's lawyer, so I have to be careful about coming on the actual case. But the status is that, just so everyone understands, because this is complicated, the status is the rule's final, right? Remember, this is a rule the FTC has issued. It's a rule that applies just to automobile dealers, right? And it's final. So it exists today. It is not as if are they going to change it? Are they going to retract it? They've finalized it. They've issued it. The only question is whether the effective date, whether it will go into effect, is the legal term. The effective date was originally July 30th. NADA and TADA sued, and now it is the FTC has stayed the rule, which means they've sort of paused it pending judicial review. So once the case is over, we don't know when that will be, sometime later this year, we think maybe. Then depending on the outcome, they will lift the stay, and they could then say, hey, it's effective in 30 days. They could say pretty much anything they want. So the bottom line of what folks need to know is, and NADA certainly has taken this perspective, is that they got to be ready. I mean, Chris and I literally wrote the guide that NADA is putting out soon, I think, on this CARS rule, although it's called the Vehicle Shopping Rule by NADA for reasons we could explain. But they are going forward with compliance guidance because people have to be ready, because this is not, I mean, it is unbelievable that they have only given people the time that they originally had given them, 6 or 8 months, to comply with this rule that is very far-reaching, right? Mm-hmm. I mean, it's very unprecedented to say, it's sometimes you'll tweak a rule and give people a year, right? This is a brand new rule with all these new obligations. They give them 8 months, right? There's almost no way that could happen. So it's such a long lead time. You got to really be ready. And to Chris's other point, some or all of this is going to be in effect in the dealer world in the coming months to years, in one way or another, whether the CARS rule goes through or not, because they've got these other rules like the junk fee rule, which impose similar obligations on dealers. So anyway, I know there's a lot of misinformation out there. I know there's a lot of questioning because it is kind of confusing. But stay tuned and be ready is sort of the this is going to happen.
And I'll address, I guess, one piece of misinformation I've kind of seen floating around on social media and stuff is that and this is my opinion, right? But it's extremely unlikely that this still goes into effect fully on July 30th. I think that's just kind of not realistic at this point. I mean, there's no way the judicial review is going to be completed by then. My understanding is even if oral arguments are granted, which they likely will be, where both sides can kind of present their side of the story to a judge, that's not going to happen, anytime where this is going to get finalized by July 30th. So I think for some of these people saying, "Oh, you get ready, July 30th is still the FTC could do that," that's probably not realistic. So, but again, I think to Brad's point, you should still be ready. This is probably going to happen or be a force one way or another. But again, I don't think there's any world where this original effective date that's going to happen. So, just again, my opinion, but I think I'm probably right.
Well, and since we're here, and you guys are ComplyAuto, how would you help a dealer move over, assuming that the rule goes into effect and it is in its current language?
I mean, we'll talk about it. I mean, go ahead. Yeah, I mean, we're certainly working on a number of approaches. There are going to be issues that I think you're going to need sort of automated help with as a dealer. A lot of this is going to be process driven and training driven, like we said, making sure your people understand what's going on. But it's so far flung. I mean, the problem is, I mean, look, the basic buckets of obligations are: don't make these broad misrepresentations, right? So you're going to have to train people. You have to make sure your forms say what they're supposed to say. You may even have to do some sort of documenting of conversations with people and maintaining records. And then you've got this broad offering price obligation in advertisements and in communications. So obviously advertising compliance, and that's a piece that we're focusing on now. Chris can talk about that. And then the communications piece, because that again is going to be the biggest change, right? You're going to have to keep all these things, and you have to store them for 2 years, and you have to figure out a way to control this stuff, right? I mean, again, think about today's real world scenario in a dealership where people are calling on their personal phones, they're texting, they're on their own personal social media. You're going to have to get controls over that stuff. And so I think there are going to be some technology tools that could help dealers with those kinds of pieces. And then, of course, maintaining the documents, and then there'll be forms that you have to give the people and prove that you've given them to them. So those are sort of pieces where the vendor can fit in, but it's going to be almost as much a process issue as well. And so, training and guides and policies and things that we help dealers with are going to come into play as well.
Right. And to Brad's point, I mean, I think one of the big pieces is going to be, that he was alluding to is communication monitoring. Again, the first communication rule under the offering price requirement. How do you know if somebody violates that without monitoring through some sort of, AI or automated tool that they've done that? And how do you enforce it? That's also ripe for automation. And hopefully a lot of the other vendors, ancillary vendors out there like chat modules stuff are thinking about this. So if somebody asks about a specific car, it's set up to automatically ensure that the offering price is disclosed. Because let's be realistic, just you can train people till the cows come home, but it's going to be very difficult to enforce unless there's some sort of automation that can do that. Also, again, advertising compliance.
Go ahead, Chris. I'm sorry.
No, I was going to say advertising compliance is another thing ripe for automation. When I was at the dealership world, I've done compliance my whole career. Like one of the biggest challenges was monitoring all your advertisements. Traditionally people think of an advertisement as like a vehicle special, but it also applies to your vehicle description pages, your VDPs. I mean, every car you've got on your website is an individual advertisement. And how do you possibly, especially if you're at a large dealership group where you've got, where I came from, we would have anywhere, we'd have thousands of cars advertised at any given time. And I'm sure we all know this, but like we got used car managers and sales managers who can enter like the description notes on the car. And those are fraught sometimes with compliance issues because they'll use prohibited terms and make statements.
Easier the better.
Yeah. And now you've got monthly payment disclosure rules. So if you mention anywhere the monthly payment, then there's additional obligations that apply. You get to list the total amount of those payments over the life of the loan if you mention a monthly payment. And so how do you enforce all this? And again, I think there's a list. I think it's 16 prohibited misrepresentations under the CARS rule. How do you make sure none of those are being made? And they might seem straightforward, but they're not. And so I think, a solution like ComplyAuto has where we can automatically scan all of the websites for these issues using our proprietary technology that we've developed is an extremely powerful tool, because that's something no human can possibly do. And all it takes is a single one of those violations to get you in trouble. And so we've got a technology that's extremely powerful that can do that both under the CARS rule and under existing state and federal law. And we're the only company in the country that's developed something like that. And that will be, I think, tools like that where no human could possibly oversee this and enforce it. It's going to be right for technology, and there's really nobody better positioned than ComplyAuto to do that. Like Brad said, I mean, we're literally the ones who are writing the guide with the NADA on this. I mean, and to Brad's point that it's complicated, I mean, I've got it in front of me right now. It's currently in its current form. It's 66 pages of single spaced text, and that's not because it's unnecessary. Yeah, and that's the short version. I mean, we tried to condense it down as much as we could, but this is complicated stuff.
It's
and there's a
8-point
lot of
font
things
too, right?
Yeah, exactly. Yeah, exactly.
And again, I would just add that I think hopefully as people listening to us are thinking about this, they're thinking, oh, okay, wait a minute. So what about my used cars, right? I mean, I'm changing prices on those maybe 2-3 times a day. Think about the integration challenges, the record keeping challenges, the other things that you're going to have to make sure that you do as a dealership. And again, I think those are places where vendors are going to be relied on. Hopefully other folks in the marketplace, are willing to do what they need to for dealers to make sure that those things work together, because you can't have one price displayed one place and one in another. Think about it. Remember, from the FTC's perspective, now we talked about this first communication thing, but this applies to ads and communications. Well, that what is easier, literally, if you're a FTC compliance lawyer who's sitting in DC, are they going to be monitoring dealer communications, or are they going to look on the internet for an advertisement, right? So that's what they do. I mean, they're human beings, right? They only know what they know. So I'm not saying the communications piece is not important. It is. But it's particularly critical to make sure your ads are right, because it's very easy to demonstrate. It's very easy for someone remotely to look at, and it's what can you say, right? You have a time-stamped ad that has one price and a time-stamped ad somewhere else that has another price. You got a problem. So it's. I mean, I know that's been a long-standing problem in our industry, but it's just something for dealers to think about. One of a number of things to think about as this thing goes forward. So, and it's probably a good. That's an example of something that's probably a good idea to get straight anyway. Right. So that's kind of what we're saying before, is regardless where this comes out, there are potentially some good process things that could come out of this. Now, are you doing it under the threat of a federal enforcement action? That's never any fun. But anyway, that's one of many things to think about.
So we definitely got the CARS rule covered, or the FTC rules as they're currently out there. What else is going on? Is there anything we should be watching out for?
Anything else scary?
Yeah.
Yeah. I mean, I think one of the most timely topics is the new data breach reporting requirements, again, from our friends at the FTC. And that just went into effect on May 13th. And so that is new. And again, some kind of confusion out there, because there was the original safeguards rule, which was I think 2002 was when that was first announced and passed, and then there was the revised safeguards rule that went into effect last year that imposed all the new cybersecurity and data security requirements like MFA and continuous monitoring, penetration testing, and encryption and all that, right? And then there was another one, so it got revised, or there's another amendment that requires now financial institutions, including dealerships, to publicly report to the FTC any data breach affecting more than 500 or more consumers of unencrypted data. And that is a game changer, in my opinion, because one, the safeguards rules now almost been out for a year, and the FTC has been pretty silent. They haven't, I don't think there's been any public enforcements specifically under the Graham Leach Bliley Act revised safeguards rule yet. And now the FTC has really more authority, I think, and more incentive to start enforcing this. And remember, the cited reason from the FTC for this amendment was so that they can really target the companies that have data breaches for possible violations of the revised FTC safeguards rule. So the kind of irony of it is you report to you have to report to the FTC that you had a data breach, and then the FTC's reason is to come get you in trouble for it, right? Or find out if you violated the safeguards rule. And there's also serious reputational, not only enforcement risk for that from the FTC, but reputational issues, because the FTC has stated it will make those public on some sort of website. I don't know how they're going to do it, but those data breaches will be made public, unless law enforcement has asked them not to for investigation reasons.
Let me just something Chris said there. A couple of things Chris said. First of all, yes, this is a big deal. I mean, people ask me all the time, when have you heard anything about the safe? And remember, for everybody out there in the world, this gets confusing. We were talking about the cars rule. That's the rule that the FTC, that's still sort of pending out there, that it applies just to automobile dealers. Now we've switched gears to a different rule called the safeguards rule. All right, it's easy to get confused. When we live this stuff, it's easy to forget how confusing it is. Safeguards rule, as Chris said, has been around for a while. That's the one that had the big push and the due date from the last year. So this is in effect today. You need to be compliant with the safeguards rule today. And what we're talking about is another change on top of the thing you had to do as of last summer, right? So this is new. And as Chris said, it means that if you have an issue, and it's very unclear in the way they define what the issue is, but it's basically a breach, you have to make a report to the FTC that they post on a website that anybody can see. So it's frankly, a little shocking to the conscience that they passed this rule not to notify consumers, not to help with data security, but just to basically, so you're publicly named so that they can bring an enforcement action against you. So a lot of folks saying, what's going on with the safeguards rule? I can tell you 20 years ago when this thing came out, what they did was about a year later, they issued this letter to a couple hundred financial institutions and said, hey, where do you stand? That may be what they do, but I think my suspicion is that this is going to be the trigger, because what this means is you got to tell the FTC if you had a problem. Then they come in and they say, after the fact, with their 2020 hindsight, they say, well, you probably violated the safeguards rule for some reason, or at least they'll allege it. So hopefully you've got yourself buttoned up as well as you can, because there's very big issues that are raised if you have to make this reporting. So that is a big deal, and that's why it's a big deal. You should be complying with the safeguards rule anyway. There's lots of risk there, but this is going to really focus the FTC's mind. So.
Yeah, well, and my concern is even dealers who have kind of made a good effort to comply are not fully compliant, and so if and when they have a data breach, and remember, even the most secure companies in the world have data breaches, and so I think dealers are often a target of data breaches, and so even dealers doing a lot are going to have to face the reality that they could still have a data breach even if they're doing everything they possibly can. And that could trigger FTC investigation and scrutiny of whether they're complying with all of these elements of the safeguards rule. And even a lot of well-intending dealers, I fear, are missing key elements. And I'll just highlight one of those, for example, that doesn't get a lot of attention. And we just, Brad actually just wrote an article about this for us, is the what they call unauthorized activity monitoring requirement, where dealers are required under the safeguards rule to have a system in place for monitoring unauthorized activity by their own users or employees, in other words, or even potentially vendors that have access to their system. So not from unauthorized people. There's a requirement for that too, for example, bad actors and people trying to hack the dealer system. But this is a separate requirement for authorized users, meaning, and again, a good example, the one we just wrote an article about, it was kind of timely, is there was apparently some story about a dealership service employee that was terminated, and he kind of used ransom, a bunch of information that he put onto a thumb drive at the dealership, and said, unless you give me a severance of X amount of money, I'm going to release this sensitive information to the public, right? And that's the kind of thing the FTC would want you to have a system in place for detecting and preventing. I don't hear any other compliance company talking about that. I don't see them offering other tools to do that. And it's kind of, again, to me, one of the most under talked about. And there's a few of those. That's just one example. And it's like, are you doing this as a dealership? And most are not. And so there are tools out there to do that. For example, and it's just kind of good business anyway. Something should have either, one, prevented that service manager from being able to put that stuff on the thumb drive in the first place. For example, policies that prohibit people from mass putting stuff onto an external storage device. Like, there's tools out there, including ours, that can do that. And then other, alerts. So you have an employee that starts mass downloading stuff from your CRM. You probably want to know about that. You have an employee offloading or sending an email with an attachment that has thousands of customer records, maybe because they're a disgruntled employee that wants to steal the information and go to another dealership. You should probably know about that. And these can constitute safeguards rule violations. And again, I would bet if the FTC does an investigation on you, if you had a data breach, they're going to check if you're meeting all these requirements. And so, there's a certain element of, like, there's the obvious kind of basic stuff you need to do, and then some of these more technical requirements that in my opinion just don't get enough attention.
So, what
You
are
know,
the financial hits a dealer could take for being found in a bad spot with the FTC in these regards?
Yeah, I mean, it's yeah. I mean, Brad, go ahead. You
I was just going to say it's okay. Lots. There's a lot to unpack there. So, generally speaking, what the FTC does is they say if you violate one of these rules we've implemented, it is deemed to be a violation of what's called Section 5 of the FTC Act. So that's sort of their broad, unfair, deceptive acts or practices authority, right? A lot of states have UDAP statutes. This is the federal UDAP statute, right? But they tied in, and the strict answer is violations are 51,000. I don't remember the exact 51,600 some dollars per violation, right? That's what the FTC could come in and fine you for if you were found to violate one of the provisions. Now, that's the CARS rule. Arguably, if you violate the safeguards rule, it's a similar issue. But I think FTC enforcement actions are very important, and they can be painful to almost fatal if they come. So don't get me wrong, but they are a little less common. I think the one of the bigger risks is, and the FTC is at pains to point this out. For example, in the CARS rule, neither of these statutes have, or the rules have, private rights of action. So in other words, someone can't sue you saying my cause of action in federal court is that you violated the CARS rule or the safeguards rule. But what they can do is they can sue you under state law. And I'm getting a little legal wonky here, but they can sue under state law, even in a class action. And in some states, they're able to sort of bootstrap the state claim. Their basis of a state class action is, hey, you violated this federal obligation. That violates my state statute. So my point is, there is some potential class action liability for this, which of course is only heightened when you have a public website that you have to report a breach on, that kind of thing. So there's that, and of course I wonder. But lastly, and then anytime you have a data breach, stopping a breach is the most important thing here. But if you have a breach, you have all these follow-on issues. There are a lot of plaintiffs' lawyers that are looking to sue businesses of all kinds when there's been a breach, and that's an evolving area. There's risks.
Yeah, there's almost a 100% chance if you have a data breach that you're going to receive some sort of class action under state law. I mean, I'm almost invariably, every time I see a public data breach, like within a week or two, you've got the plaintiff attorneys in the state, claiming you violated the state laws, and either negligence or some broad unfair business practice, or even a lot of states provide for a specific private right of action under if you have a data breach. And so that to me is probably the bigger risk, even than the FTC, is you have a data breach, you're going to probably have private plaintiff attorneys going after you for that, because of the damages the customers are going to allege because their identity was exposed.
And look, I'm scaring people is one thing, and they're very real risks. I always like to also point out the fact that dealers should be thinking about this stuff for a bunch of other reasons. What about cyber insurance? What about the contractual requirements from their OEMs or their finance companies? These folks are basically saying, dealers are probably making promises in their contracts that they don't even realize that they're doing all these things with respect to data, in order to get information that they get from financial institutions or the OEM or whoever it is. And so the entire atmosphere here is the bar is being raised tremendously. So, there are other risks in addition to just being sued, that just says, look, this is just going to it's going to cost you money. It's going to mean you can't comply with a contractual obligation or do something that you need to just to do business. So it's just kind of becoming the price of entry, right? Doing these things for data security, and dealers do handle very sensitive data. They really do. And so, that's kind of how we've gotten this world. That's why you're financial institutions as a dealer, is because you handle sensitive information. Credit applications and things are about as sensitive as it gets. So anyway, it's a broad question, and there are certainly plaintiffs' lawyers out there looking to take advantage of it, but there's also really important business reasons the dealer should focus on this stuff too.
Yeah.
Stunned silence. That's what you get when you hear these things. I know, I get it, and there's a lot more out there to be worried about. I will tell you, in terms of triage, the safeguard stuff is very important, obviously. I mean, the CARS rule is coming. You got to be ready for it, and it is real. But the safeguards issues, you really need to be buttoning that up. I mean, I'll just add one thing on the safeguards rule. And this is, we talked about this recently at ComplyAuto, but we certainly talked at NADA. One of the requirements is an annual report to your board of directors, or if you don't have one, basically to the dealer principal, right? And I always tell people, why did they put that in there, right? Well, they put that in there because there's a growing trend and a very explicit desire from the regulators to hold people at senior levels of the organization responsible, right? And so they don't want people saying, "Oh, I didn't know this was going on. I'm not responsible for it." So they make the qualified individual at the dealership report to the board of the dealer every year. And the reason for that is so the dealer can't say, "I'm sorry, I didn't really know what's going on," right? Because they want to hold that person responsible. In fact, what they've done in a lot of the last few enforcement actions, an increasing trend, is they find the company, they do whatever they do, and then they penalize the CEO or the head of the organization personally. And so I'm again mentioning that not to scare people, just to be aware. I mean, you have to ask yourself, why are they doing this? That's why. So if I'm a dealer out there, I'm saying to myself, I need to understand what's going on here. I need to have, I get it. This is not always top of mind for all dealers, but you do kind of need to know at least what's going on, because they're seeking to make you on the hook personally, whether you know what's going on or not. So just a message to think about.
Sure, it'd be nice if we could hold them accountable someday.
Well, elections do have consequences, at least theoretically. I'm not suggesting anything other than just that's, at least in theory, our democratic system of work. I mean, there are efforts on Capitol Hill, there are efforts in the courts, there are obviously efforts in all three branches of government to push back. And so, there are people out there trying to work on behalf of dealers and consumers to do the right thing, but sometimes it takes some time. So
I'm thinking about operational costs. This is definitely going to add to a dealership's operations, whether it's software, whether it's auditing, and then I think about your small little independent stores, because they're going to have to follow the same rules, same regulations. The additional operation costs that this is going to add to those. Do you see this having a huge impact on your small independent dealerships?
Yeah, and I mean that's the unfortunate reality. And I mean, look, ComplyAuto has we primarily represent new car franchise dealers. We do represent, probably, I guesstimate here, but around 1,000, independents or used car dealers as well. But yeah, I think there's a disproportionate impact on the independents. I mean, it's fine. I mean, you look at the NADA did a study on this, and I forget what the numbers exactly were, but it was like a $200,000 plus upfront cost to comply with the safeguards rule, and then a $200,000 plus yearly cost to continue compliant with the safeguards rule.
300,000.
Oh, 300,000. Wow. Okay. And so a lot of that, like software, like ComplyAuto's, system, which we think can get you to close to 100% compliance, if not, 100%. Obviously it's software, so there still needs to be an effort by the dealer, and there's a cost to that, right? Somebody's got to oversee and manage all this, and you can get lower. But the problem is, that's still expensive for a used car dealer. I mean, you look at some of these DMSs, and that's typically one of the dealer's biggest expenses, right? In terms of software at a dealership is their DMS. I mean, in the independent world, the DMS could cost you $99 a month, which is extremely affordable compared to what a new car franchise dealer is paying for a DMS. And so you try to, you got IT companies and stuff come in there and saying, well, that's what you have to pay just for multi-factor authentication, right? And that's one requirement under the safeguards rule. It becomes extremely challenging to justify that cost and to budget for it. And so, yeah, I think there is a big challenge, and I don't think the FTC kind of understands this, but that these kind of disproportionately affect independent dealers, which may have 5 to 10 employees, and all the same requirements apply, and it's a lot more difficult than, say, a dealer like I worked at that had an entire legal staff and compliance department. So yes, I think that presents a challenge.
Yeah, I see a lot of them closing up.
Well, and I'll just mention 2 things. One is, and Chris, you can speak to this better than I can. We didn't do much of an intro, but I'm still learning my ropes at ComplyAuto after being in NADA many years. But I understand we do have special packages, and we work with the independents, and in a way that is as cost effective as it can be. But you pointed out an important thing, because the safeguards rule has been around for 20 plus years, but forever it was to do what's reasonable based on the facts and circumstances of your situation. Right. So what was reasonable for an independent dealer was different than what was reasonable for a big publicly traded dealer group. And that's what's changed. And it's unfortunate, right? The FTC just says, no, Sorry, everybody has to, all these 20 things, everybody has to do it. I don't care. There's no cost benefit analysis. There's no return. There's no ROI. You just do it, right? Because what they've said is the severity of losing that information. I mean, the argument on the other side is if I do a finance credit application with a small dealer, I should be protected the same way as I am if I do a credit application with Chase Bank, right? And that's the problem, right? And so that's why, hopefully, one of the reasons I'm at ComplyAuto, because I think that they've done a great job of leveraging technology to make it as cost effective as possible. Chris is right. We did a study, and we weren't trying to put nobody's putting a thumb on the scale. We just asked. We said, how much would this cost to do? And it was a really big number. And so the fact that vendors like ComplyAuto have been able to come in and drive it down is great. But it's not, it actually kind of means that there's not as much of it, there's no excuse anymore either to at least not investigate and do something about this.
Yeah. It feels like in a lot of ways, maybe I'm overstepping a little bit, but like our government is really wanting to do business with big companies and big corporations.
I don't know that they think about it that way. I could be wrong too. It is there. Not to get too theoretical here, but it cuts both ways, right? They don't like on the technology and the data security side and the privacy world. They don't like big companies' ability to leverage things from a privacy perspective, right? But they certainly do. I'll just give you one example. And we had this conversation when I was at NADA with the FTC all the time. One of the obligations under the safeguards rule is to monitor your third-party service providers, right? And if you're Chase Bank, or I'm picking on them, just some big bank, and you hire some company to do something for you, yeah, you can go say, hey, do what I ask you to do under the contract because I have to do it under the law. If you're a dealer, you work with your manufacturer or some very large vendor you work with, you may not be able to do that, right? They don't understand that or really think about it from the perspective of a small business sometimes. So there's no doubt that they have blinders on in terms of how the world actually works. But it is interesting because in certain circumstances they don't like the big companies and I don't know if that's a good segue if we have time, but if we were to list another thing, you asked what else we're worried about. There's another issue along those lines that we want to at least mention, which is a little understood issue, and that has been sort of under the radar, and that's the sort of a spate of private lawsuits relating to gathering information on websites, and that really has to do with this issue about big companies like Google or Facebook and other people gathering large amounts of information from consumers, and the fact that the regulators don't like that. So, Chris, I don't know if you want to weigh into that or not, but the basic issue. Go ahead.
I know we're short on time, but yeah, the basic issue, right, is scripts and cookies and pixels like Google Analytics and Facebook Pixel that are being targeted across the U.S. by plaintiff attorneys, many and most out of California, but other states like Pennsylvania, Massachusetts, Florida, and Illinois as well are kind of those are the main states where this is happening, suing dealers. Automotive technology companies. In fact, just last week, in the past week, some of the largest automotive lead providers were sued for this. And I won't mention who they are on this call because I don't want to bring more attention to it than necessary, but it's public information.
OEM,
and an OEM, and there's 5 of them just in the last week sued for this. Most of them again coming out of California. But the issue, the allegation being that without a user's consent, that deploying and tracking web activity, or using chat modules to record communications, or do retargeted advertising or analytics without their consent is a violation of the state's wiretapping and eavesdropping rules. And that is a real issue that, again, like Brad said, is very little understood. People confuse it with state privacy law. They confuse it with the safeguards rules. It's really not a safeguards rule issue, but it is a real risk that is affecting more and more automotive and dealerships. And by the way, not just automotive and dealerships. I mean, again, there's been probably over 1,000, I think now, of these lawsuits filed just in the past year. But it is a real risk that dealers need to understand because there's really 2 options when you get one of these demand letters. You either settle it, and they're typically asking for $5,000 per violation, which means, according to the plaintiff attorneys, per website visit. And so they'll ask anywhere from up to $70,000 for a single user of the website, and there's class action potential under these state laws, and that is a real risk. And there's also business risk, because if you choose to get consent obviously you could harm your analytics and harm your retargeting rates. And so dealers are going to really need to, one, understand this issue. We've published a very comprehensive guide on it from a legal standpoint, and also understand the business implications of the cost benefit analysis of getting consent to mitigate this increasing legal risk, but also the effect that could have on your online data, because you in theory, won't be able to, if a user, for example, declines cookies, that you won't have certain data like analytics and retargeting. So,
very quick, I know we're running out of time, but to your point, this is a great example of something that I think people in the marketing community in particular need to understand, which is they are purposely going after it, right? You think of this as an everyday occurrence. I'm using my Google Analytics. I'm tracking what's happening on my website because that makes sense, right? I mean, it's a great idea. It's a wonderful tool. The regulators in many states and at the federal level don't like this. The FTC has brought enforcement actions against tax preparation companies and healthcare providers and other people for just this kind of thing, right? Without consumer consent, gathering this information. So it's like this clash between something that doesn't seem like there's anything wrong with it and what the regulators and the privacy community want to do. So you just have to be really careful, and you have to. And again, I agree with Chris. The ComplyAuto website, if you go there, there's a lot of background for you or your lawyer, whoever you want, just to get, because you got to get your head around this issue. And the last thing I'll tell you from a dealer advocate perspective is the issue of what's happening on dealer websites is a huge issue that dealers need to understand. Dealers have to understand who's on there, who's collecting data, what's happening to it. So even if we weren't being sued over these practices, which dealers are getting sued, you should know what's happening, right? This is valuable information. This is important information. And there's a lot going on that you may not even be aware of, both from, third parties of all kinds, whether it's OEMs or others, that dealers really need to get their head around. So that's one of those areas where compliance and business interests could be aligned if you do the right thing, right? I mean, you really should be understanding what's happening there anyway. So, we can talk about that a lot longer, but that's another issue that people should at least be aware of.
Look, you're triggering something we've covered in the past on Dealer Refresh numerous times, where plugins to a dealer's website have been consuming their visitor data and capturing lead forms and all whatnot. And there's been suspicion that some of these might be selling off that information in the advertising networks in the back.
You bet it is. Yeah.
Yep.
Yeah. And in some of it, there's a certain level of surreptitiousness, if you will, to some of that. I mean, we're deep into this issue at ComplyAuto, obviously, because we have the cookie banner and we classify cookies across dealer websites. And I'll tell you, there is a world of where there is an element of this being done almost intentionally, secretly, right? Because you can embed cookies within a script that may not even be apparent to the dealer. You can embed cookies within iframes and these widgets that go on the dealer's websites that can collect information, that dealers don't have a lot of control over. You can embed other cookies in tag managers that the dealer may not realize are being embedded. And all of that is very kind of, unless you're a very sophisticated technical individual, you don't know happening, and there's not always a lot of transparency onto where that data is going for whose benefit. And
Chris, the vendor might not even realize it's happening.
So there are a lot of people trying to do the right thing, but there are some people that, to Chris's point, that clearly, when you really dig into what's happening, when people are sort of trying to disguise what they're doing, that's never a sign of something that is something that dealers probably want to have happening. So yeah, it's
Yeah, now with these lawsuits, I mean, even more reason to know what's going on your website. Yeah. And that's not always happening. Again, I'm not trying to say that every dealer website has this going on, but there's an element of that going on out there. And as a dealer, I think especially again with these class action lawsuits, increased scrutiny from the FTC on this issue, even against GLBA regulated entities like tax prep companies, dealers need to have an understanding, a very deep understanding of these issues, get their marketing companies involved, get their lawyers involved, probably more importantly, to make sure that they're making the right business and legal decision.
Yeah, look, it's just complicated. It is complicated. We speak to lawyer groups of lawyers and explain this stuff routinely, because it's if you don't live and breathe this all the time, it's very easy to get this complicated. We've talked about 4 or 5 different statutory schemes at the federal and state level that all have different interplays with each other. So understanding these pieces is not always easy, but you got to make a little effort to get it to get your hands around it. It's got business implications and it's got some liability implications as well. So we'd encourage dealers to do that.
And vendors too, if you're using any freeware to build your software, take a big, heavy look at that stuff.
Yeah, there's been lawsuits on that exact issue. Yeah.
Yeah, I mean, look, anytime that there is something of value that can be obtained and utilized without much of a record or awareness of what's happening, it's kind of human nature, right? I mean, especially when you're like, well, then, no, it doesn't hurt anybody. I'm just gonna, I'm gonna be taking this information and using it for myself. I mean, it has value. It's important. I mean, think about it. Your website is sort of your storefront, right? As a dealer, it's like people coming in and taking your, rifling through your CRM or your leads, right? So it's important. It's just because you can't see it. It's sometimes hard to quantify how important it is, but it's critical.
Well, gentlemen, as usual on these topics, I leave with a feeling of woe, but it's a very much appreciated feeling. By the way, this education's priceless.
Well, no, all is not lost, and there are some people out there trying to help dealers, and so find some people you trust. And there are the world's getting better. Like I said, I've been around to doing this stuff for a long time, and it's gone from the Wild West to a semi-controlled chaos. So we're getting there, but find some people you trust, and you can get there. So it can make a difference.
Perfect.
That's a good, encouraging finale. Thank you, sir. Well, everyone, I hope you have a good weekend. Thanks.
Yes, thanks.
ComplyAuto.
Thank you so much.
Thanks. Great to talk with you all. Thank you.
Take care.
Bye-bye.
Take care. Bye.